Try that again. Good morning, everyone. We're going to give it just another minute or two while everyone gets into the session. We want to make sure that everyone has the opportunity to hear from the beginning. Just one more minute because I see the numbers going up. Okay, I think we can start. Good morning. Thanks for joining us today for our annual New Laws for the New Year webinar, Navigating Changes in Employment Regulations in 2020. This webinar is presented by Ethos Human Capital Solutions and Merhab, Robinson and Clarkson Law Corporation. My name is Denise Keddy, and I'm your moderator for the session today. I want to give you a couple of quick housekeeping notes before I introduce today's expert panel. The webinar will probably run longer than our normal 60 minutes, and that's okay. We're going to try to answer as many questions as we possibly can, but do know that we do record the webinar. I'm going to add the link to the presentation in the chat area for you to download. I'm going to send that right now. And I'll send it a couple of times during the session just to make sure that you get that. If you have questions, you can type them into the Q&A area anytime during the presentation. And if you'd like your question directed to a particular person, please make sure you mention that in your question. If you have any issues during the presentation, just click into the Q&A section and I will respond to you as best I can. Just a quick reminder that today's presentation is being recorded and all accompanying materials are protected by copyright. Our presentation today provides general information and does not constitute legal advice. The information offered is as of today, December 7th, 2023. As always, we recommend that you contact your own legal counsel to address your specific situation and ensure you have the most current information on your particular legal matters. Our webinar today is approved for HRCI credit. If you want credit for your attendance, please complete the follow-up survey when you receive the link. Once you complete it, you'll receive the certificate. So let's get into the session today. A new year brings new beginnings, and of course, we have a lot of new labor laws to go over. We've been doing this for years. Our legal expert today is Kurtis Urien. Kurtis is an associate at the law firm Merhab, Robinson and Clarkson with the firm's transactional department, where he advises clients in real estate, finance, business succession planning, corporate, and employment law. In addition to his work, Kurtis has contributed to multiple law journal articles. He's a part-time lecturer and has taught classes in economics, conscious capitalism, and business law. Kurtis has also been recognized by superlawyers.com as a rising star in Southern California, and he has kept this record going from 2017 to 2024. Our human capital expert is Linda Duffy, who is the president of Ethos Human Capital Solutions. Linda and her team are known for building the magic of human connection with their consulting, recruiting, training, and also payroll support programs. The Ethos team works with your company by developing strategies for business leaders to get the right systems, people, and culture in place within your organization so that you as a business owner can focus on running your business and achieving your goals. Her clients range from high-tech businesses to manufacturing firms to nonprofit, and she is extremely well-versed in addressing the concerns of founder, CEO-led businesses. Linda, could you get us started this morning?
I can. Thank you so much, Denise. This is our agenda for today. We're going to be talking about all of these different changes. Starting with minimum wage. I'm not going to read you the whole agenda, so just know these are the different topics that we have to talk about, including some case law toward the end of this. So we're going to get started and talk about minimum wage increases. So probably everybody's heard by now. Next year, starting January 1st, $16 an hour will be the minimum wage California-wide. Now, keep in mind, of course, there are a lot of local ordinances, local cities that are paying a much higher wage as a minimum, right? I think like Emeryville is, 18 something an hour now. So you always have to check to make sure that your city, county, local laws don't impose a higher standard, but that's $16 per hour minimum wage across the state. That's tied to the annual minimum salary for someone to be considered exempt. And I think every year, Kurtis, we talk about this. And when, Ethos goes in to do audits, we ask for a list of all the employees and the amount that they make and how they're classified. And the first easy sort is, okay, are they making a minimum of $66,560, right? You must come across that as well. I'm sorry?
All the time. Sorry,
Yes.
can you hear me? Okay,
Yeah,
great.
now we can hear you. And so they also not only quote this as an annual minimum salary, but then they break it down monthly, semi-monthly, bi-weekly, and weekly. Don't ask me how they do their math. It's not the way the rest of us do it. So just make sure you take a look at that as well. The next big change for next year is paid sick leave. So for the last several years, I think it was 2015 or so, we had the Healthy Smiles, Healthy Family law that went into effect that required paid sick leave for 3 days or 24 hours, whichever was greater. Starting January 1st, if you're front loading, that's 5 days or 40 hours, whichever is greater. And the reason we say it that way is some companies are on an alternative work week of like 4 10-hour days. So they would have a different minimum standard, because you would have to give them 5 days worth. So in their case, that would be 50 hours. So just make sure you're taking a look at that as well. You can still do the accrual method that's been in place. That's 1 hour for every 30 hours worked, but now you have to increase the amount that they can roll over, and the cap is now 80 hours or 10 days, but you can still limit the usage to 5 days. So Kurtis, I don't know about you, but we always recommend they front load. Is that what you do as well?
Absolutely, very much. I've seen an employer use the front load method, and the reason for that is because it's much easier to track and implement. The statutory approved accrual method is a great way to do it, but it requires a lot more administration. It requires a lot more work.
Well, and it also is a challenge when somebody sees on their pay stub, oh, I have, 100 hours of sick pay. And then you say, no, you can't use all that. Right.
Yeah, it
So,
gets confusing. No, you can only use half of that.
right. Why don't you take it from there, Kurtis, with the alternative method?
Right. So one of the things we want to do with this slide is just kind of simplify the update here with the increases from the legislature. I've read the bill. I've seen a lot of other updates and email blasts, and there's a lot of confusing information. So I just really wanted to simplify it here. Like Linda said, the front load, it's greater of 5 days of 40 hours. Accrual method is the same. It's just the cap is increased. You can still use the alternative method of granting paid sick leave per month as the employee works, and the rate is the same. So what I'm talking about here is the alternative method. The rate is the same. It's just that the cap, again, is increased to 10 days. And there's also an allowance for grandfathered policies in the law. I don't know if there's any left, but if your policy from pre-2016 it still complies, you can still use it. But I'm going to guess that there's not many left. And like Linda said, for the minimum wage law, there are a number of local ordinances, cities and counties that have adopted their own paid sick leave rules. So that's another area to be watching out for, not just the state requirements, but your local ordinances as well, like San Diego, Los Angeles City, San Francisco City. Those are just a handful of local ordinances that have their own paid sick leave laws. And when you are in a locale with its own paid sick leave law, you have to follow whichever law or ordinance is more restrictive, or whichever law or ordinance requires you to provide more paid sick leave. So try to be aware of that. Try and look out and see if you're in a location that has a local ordinance. And with this update, with this increased amount of paid sick leave, this is also going to affect companies that have a combined vacation and paid sick leave policy, or companies that combine their vacation and paid sick leave into one single PTO or paid time off policy. Since paid time off or PTO policies must comply with both the paid sick leave laws and the vacation laws, you're going to need to review your PTO policy to make sure that it still complies with the paid sick leave laws with this change.
Yeah,
And if you have any
something.
questions on that, yeah, go ahead, Linda.
Yeah, no, I was just going to say also, I had a great question from a client earlier this week or last week where they're saying when this law originally went into effect, it was a July 1st start date. So a lot of clients have that as when they, front load again is July 1st, right? Instead of January 1st. So their question was, okay, now we're coming up on January of this higher level. Do we front load again on January 1st? And so my response to them, Kurtis, and I just wanted you to weigh in on this. My response was, you could do it a couple different ways. You could add in the extra time, I suppose, January 1st, right? But I would just switch them over to a January 1st start and just make it cleaner that way, because going forward, most likely that's when other changes will take place.
Yeah, I'm on board with that. For simplicity, for administration, I'd rather just change your policy so you're front loading on January 1st of every year.
Right.
If you don't want to do that, like you said, you can add the extra time in on January 1st and then continue to do your reset every July 1st. But the laws do allow you to change your paid sick leave policy periodically. So I would just change it, make it simple.
Yeah, because I didn't look into this and we haven't had this conversation before about is it even possible just to add, the extra amount, right? Could we just add an extra 16 hours because is that compliant? I don't know. You're our legal expert, so I'm not trying to put you on the spot, but it's an interesting question, right? Because if they have a requirement to have 40 hours available on January 1st, if that's how the law reads, then that would not be compliant in my opinion. So just something to think about, I guess, and talk to legal counsel about. Okay. Also remember that on your wage theft notice, which is the 2810.5 form, you're required to give all non-exempt new hires. You have to also make that change on that form as well, right? So you're going to want to update your handbook accordingly, but you also need to update your wage theft notice to make sure that you're saying the higher level than there was before. There's also a requirement in the paid sick leave. This policy must be in writing and disseminated to all employees. So if you don't have a handbook, just remember you have to have a written sick pay policy. And then finally, the available sick time has to be provided to the employee in writing. If it's on a pay stub, great. If not, you have to come up with a different writing instrument in order to notify them how much time they have remaining. And then we mentioned the wage theft notice. This is ours. There is a new requirement also to add this information that says, hey, in the past 30 days, has there been a federal or state emergency or disaster declaration applicable to the county or counties where the employee is to be employed? I told Kurtis, I don't even know how to find this information, but you're now required to have a yes, no on the new wage theft notice to notify the employees whether there's been some sort of federal or state emergency in that area. Okay, and just real quickly as a reminder, there was a new I-9 form that went into effect on on November 1st of this year. Hopefully you've all already downloaded and have been using it for the past month. If you were not on our last webinar, there's a link to it on YouTube where you can watch and find out more about that form and the new requirements and the changes that were made. Kurtis, you want to address the in-person verification?
Right. So with the COVID pandemic and many employees working remotely, the DHS issued some temporary regulations that allowed remote verification of identification documents. Those regulations have expired. Even though they've expired, there's a lot of people still working remotely, and there's a huge demand from employers and employees to allow for remote verification. So the DHS is slowly working on some permanent regulations for remote verification. So far, the DHS has only rolled out a regulation that allows for online verification for employers that are e-verify accounts. So if you want to do an online verification of an I-9 or identification documents for an I-9, you can only do it if you are an e-verify account. If you're not e-verify, then you still must do the in-person verification.
Yeah, and the webinar lays out a few different options for doing that in case you need help with that. All right, Kurtis, so there's a new law on marijuana.
Yeah, so the new law generally is no discrimination for off-the-job usage of cannabis. The issue that's been presented in California is that with cannabis being legal for more than just medical usage, when a person consumes cannabis, the metabolites, the evidence of the cannabis can remain in your system for a period of time that's longer than your intoxication or psychoactive period. That the metabolites can remain in your system for 30 or more days. So potentially you could use cannabis, wait 30 days, go get a background test and do a drug screen and test positive for cannabis, even though you're not presently intoxicated. So what the legislature did is basically make it legal to discriminate for cannabis use for off-the-job usage, which is going to make things a little confusing. So here's a few tips that they've come up with and recommendations that we've come up as well. Employers can still have drug and alcohol-free workplace. So just because an employee can use cannabis off the job, you can still prevent and restrict employees from using cannabis on the workplace. You can still use screening for off-the-job usage for certain exceptions, such as government contractors or screenings required by law. But generally, if you're going to do pre and during employment testing that involves or tests for cannabis, you can only test for current intoxication. So you can only test to see if an applicant or if an employee who's working was currently intoxicated at the workplace. So there's different types of tests. I don't know much about them, but there's different metabolites and there's different chemical compounds that can be tested for, that can be screened for. So talk to your clinic about what kind of testing can be done.
Yeah.
Go
And
ahead.
so, I was just going to say, just to be really clear, Kurtis, people can still have a no pot policy, right? Like when we looked at the
Right.
handbook, we didn't make any changes to our template this year on the drug and alcohol policy, because you can still say, hey, sorry, you tested positive. But the difference now is there has to be a little bit more discretion, I guess, or more specificity to the testing positive part of that.
Right. The clinic has to do a test that tests for current psychoactive compounds. Meaning you can't just do a basic test for metabolites in the system that may have gotten into your system 30 days ago. You actually have to test for the specific compound that makes you high at that time, basically.
Yeah. So hopefully the clinics know how to do that. So,
yeah.
All right, moving on to reproductive loss leave. So California already has a ton of different leaves of absence, as all of us know. They've added a new one for 2024, reproductive loss leave. So this applies to all employers that have 5 or more employees. It is unpaid time. You don't have to pay it, but you do need to provide 5 days off for reproductive loss. And they define that as things like having a miscarriage, even a failed adoption. So it doesn't even have to be medical in nature, but if they need time off to sort of, we'll say, recover from whatever it is emotionally or physically, they're entitled to up to 5 days off. Employers cannot request documentation to substantiate the need for the leave. So if somebody comes to you and they say, hey, I need time off for reproductive loss, I don't know how you have any option to do anything about it. But just remember to add this into your handbook along with the other leaves that you have to cover. Kurtis, anything you want to add to that one?
I'm actually a fan of this law. I know people who've experienced each of these categories, and so I've seen the trauma and difficulty that people experience. So I may be in the minority, and that's okay, but I'm actually a fan of this law. And one more thing to add is that this is for the potential leave is for both people intending to or expecting to become parents. It's not just the we can't say mother anymore. It's not just the birthing person.
Yes. All right, great. And the 5 days do not have to be taken consecutively, but they do have to be taken, I think it's 90 days, Kurtis, 60 or 90 days, right after the event. All right, great. All right, let's talk about the PUMP Act. You want to take that one?
Yeah, so recently this passed the Pump Act, and it was kind of a miracle that both sides of the aisle agreed to pass this bill. But we'll see that the Pump Act is substantially similar to existing California law. California law already had fairly detailed requirements for allowing a lactation or allowing expressing of milk at work. So if you read through this, you're going to think, well, this sounds exactly like the California law, and it basically is. So if you weren't aware of the California law already, now is a good time to remember it and make sure that you've complied with these requirements and that you've added these requirements to your employee handbook, and you have a policy for lactation or expressing breast milk at work. So the basic requirement is that the employer must have a separate private room that's not a bathroom or break room, that has a sink, and well, it has to be suitable for lactation. And we basically understand that to mean a room with a sink and running water, refrigerator, freezer, seating, flat surface, electrical outlet, or at least access to these items so that lactation can be done comfortably at work. There is an exception though, for employers with 50 or fewer employees, that a separate room, a lactation or birthing parent room does not need to be provided if there's an undue hardship on that employer, which is probably going to be tough to prove.
Definitely tough to prove. Okay, there's another federal law that mirrors California's pregnancy disability leave law called the Pregnancy Workers Fairness Act. Again, if you're, I assume that everybody on this webinar is going to be California based. So from a California standpoint, it's really, there's no change compared to what the federal government's offering. Do you want to talk a little bit about transfers and workplace accommodations though? Because that does come up quite a bit.
That's come up quite a bit. And the federal law, again, a miracle that it passed. The federal law, again, basically mirrors California. So there's really nothing new for us. It mirrors the transfer requirements that the California FEHA and PDL laws have, that if an employee requests to transfer, then the employee may be entitled to the transfer if it's reasonable and can be granted. Same for workplace accommodations. If the employee needs a chair to do her job, then provide a chair. If the employee needs extra breaks, then you can provide extra breaks. It's basically the same conversation that we're used to in California. It's just now it's expanded to federally all 50 states.
Right. So again, if you have people that are in different states, just remember to update your handbook to reflect that new law. Kurtis, I think that when we were preparing for this, you called this a dumb law. Want to talk about this one?
I'm a little bummed that you edited that out. Humor aside, so I often get a question of, I'm talking to employers, and I often get the question of, how long do I have to wait before I terminate this employee after they come back from whatever leave of absence? And there isn't an answer. There's no, you must wait X number of days before you can safely terminate an employee, because very often we see situations where an employee is having performance issues or behavior issues, and the employee sees the writing on the wall, and then all of a sudden the employee is on a leave of absence because they don't want to get fired. And when that person returns from their leave of absence, the employer still wants to get rid of that person because they still suck at their job. And the employer, like I said, often asks, how long do I have to wait? There really isn't an answer until now, sort of. There's a new law that says there is a presumption of retaliation if an employer takes an adverse action against an employee within 90 days of the employee engaging in a protected activity. So say, for example, employee comes back from a medical leave of absence on January 1st. If the employer terminates that employee within 90 days after January 1st, there is a presumption of unlawful illegal retaliation. However, this presumption is rebuttable, meaning that all the employee has to do is claim this retaliation, And then the burden of proof shifts to the employer to demonstrate a good faith, non-retaliatory motive for the adverse action. This was already the procedure for establishing proof of discrimination or retaliation. I'm not really sure why the legislature decided to pass this law, because the employers still had before this law goes into effect, I mean, as of today, employers have the ability to demonstrate a good faith, non-retaliatory motive for the adverse action, but it's just going to create more work for employers and cause more headache, and it's just going to be trouble. I don't like it. It doesn't really change anything. It's just going to cause more trouble.
Yeah.
But just know that, yes, there is a 90-day presumption of retaliation now.
Yep. Yeah, it's going to definitely create some issues. All right, let's talk about non-competes, Kurtis. They're still illegal.
Yeah, this has been a concept in California law for a long time, that non-compete agreements or restrictive covenants in employment agreements are unenforceable under California law. That didn't stop employers from including these restrictive covenants in employment agreements, because employers still wanted to scare or chill employees from competing. So the legislature's response, even though a restrictive covenant is not enforceable, employers will still include it in their agreements to try and prevent it from happening, thinking that the employee doesn't know any better and will believe the contract, even though it's not enforceable. But now the legislature's decided no more of that. From now on, if an employer has an employee sign a non-compete or includes these restrictive covenants against competition in an employment agreement, it's now a violation of law of possible criminality. And there's now an affirmative notice obligation to all employers who have previously engaged in this practice. They need to go back and notify all their employees that they've done this with before, that their non-competes, their restricted covenant terms are not enforceable. And just know that can't do it going forward, not even to try and scare employees. You can't do it, because it's now an actual violation of law, not just an unenforceable term.
Right. Okay, fast food and food handler cards.
Yeah, not much to say here. If you are an employer in the fast food or restaurant context, just know that there will be some regulation and rules applying to fast food restaurants. They're even considering a higher minimum wage specifically for fast food workers. So we'll see where that goes. And then on the same topic, employers in the restaurant industry, if you have employees who are required to have food handler cards, then just know that the employer is required to pay for the employee to get that food handler card, unless the employee already has one. So if you have an employee that applies for a position, already has a card, you don't need to pay for it. But if you have an employee that applies for a position, doesn't have it, and you want to hire that person, you have to pay for that person's food handler card.
Artificial intelligence has been in the news. In fact, I think last month was when that was the subject of my main newsletter. So it's fun, right? We've all played around. In fact, one time Denise and I when we were working on that newsletter, we actually put into ChatGPT, like, what are problems with ChatGPT? And it gave us an answer. So it was humorous, but there's definitely some issues that you need to be aware of, right, Kurtis? Because we updated our handbook to include actually a paragraph on artificial intelligence, because it can get you in trouble.
Right. So generative AI is developing to be a very helpful tool, but it's not quite there yet. There's still a lot of issues with it. I added a bullet point here about some attorneys in New York that got busted for relying on some fake authorities that ChatGPT made up. There have been some employers in California that have been busted for engaging in discriminatory practices in their hiring, or engaged for just unlawful discrimination in their hiring practices, because they've been relying on AI to tell them who to hire. The problem is AI doesn't really know how to sort bias or unlawful discrimination yet. So if AI goes to its database or the internet and wants to know the best type of person to work as, I don't know, say a bricklayer, then the internet's probably going to see that 97% of bricklayers are men. And then the internet's going to say, or the AI is going to say, well, you should only hire men, which is per se illegal. So we, like Linda said, we are now drafting generative AI policies and recommending that employers include those in their handbooks or include those as their policies, and that employers take just be very careful when starting to use generative AI, and to not to use generative AI in their hiring practices or any of their employment practices yet, because it's not quite where it should be.
And then the never-ending arbitration.
Yeah, we talk about arbitration a lot because arbitration cases happen a lot. A bit of quick history: the United States Supreme Court overruled some California cases and some California laws banning or prohibiting arbitration in the employment context. So thanks to the United States Supreme Court, we know that federal law preempts state law when it comes to arbitration, meaning that the state cannot pass laws that disagree with or are different than the federal arbitration laws. Still, California really doesn't like arbitration in the employment context. I don't remember if it was a year or two ago, but after this United States Supreme Court case, California passed another law that said you cannot have an arbitration agreement as a condition of employment. Well, of course, that law got was litigated, and was found to be unenforceable because it violated this United States Supreme Court case. But it's being appealed up again to the California Supreme Court, and based on what the California Supreme Court does, they're probably going to uphold the law. You'll see when we get a little bit later to our slides of cases that are currently before the California Supreme Court, that there is a case that this very law is being considered before the California Supreme Court right now. So we're not really sure. We can't give you a black and white answer on whether you can have an arbitration agreement as a condition of employment. Even though we're not sure if this law is going to be upheld or not, and even though federal law preempts California state law on arbitration, when an employer and an employee enter into an agreement, into a contract, that contract is still subject to California state law on contracts. Meaning, if there are any contract defenses that are available under California state law, those contract defenses would be available to the employee to try and terminate or negate the arbitration agreement. And the main argument, the main defense that we see get thrown at arbitration agreements is the concept that the arbitration agreement is unconscionable. It's not fair. It's so unfair that it shouldn't be enforced. So there happens to be a case that's determining that very question as well for the California Supreme Court as to whether arbitration agreements as a condition of employment is unconscionable. So we'll see what happens with that case, hopefully in the next few months here. But even when that law was passed that's been challenged, I tried telling people that it's probably a good law because you still can't force people to sign a contract. Forcing people to sign a contract is not permissible. We also wanted to take a moment here to review some of the recent cases that have been decided here in California that apply to the employment context. These are just some of the major cases that we wanted to quickly touch on. Linda, are you familiar with the Ty versus IBM case?
Yes, I am. So those of you that We talked a lot about this during COVID in particular. You know, what do you need to do, especially if you have employees working remotely? And there's been a few different cases that have said you must reimburse employees for their expenses. This one was a little bit differently because we took the approach during COVID of, hey, during COVID, when the governor shut everything down, everybody has to work at home. But generally, it was a voluntary thing, right? Setting aside COVID, people would come, especially since COVID, and say, "Hey, is it okay if I work from home on Friday?" Employer says yes. This law or this case said even if it was due to COVID, even if it was due to their volunteering or wanting to work from home, the employer is still responsible for the reimbursement of expenses. So things like use of electricity, internet, computer, phone, whatever it could be. And so the problem with all of these laws is they never tell you how much or how to calculate it or anything like that. You're sort of on your own until somebody challenges it. But the best practice is going to be to either have them put in an expense report, or like all of Team Ethos works remotely. So it's just something that's a flat amount that's added to every paycheck just to cover those expenses.
Yeah, and it's been interesting to see the impact of this case. And like you said, Linda, I'm generally recommending to clients that if it's an expense that's been incurred for remote work, just pay it.
It's not worth
It's not
the
worth
few
fighting.
dollars.
Yeah.
Yeah, it's not worth the few dollars.
All right. So we also wanted to talk about a series of cases that discuss rounding practices. This is generally if, let's say you have an employee that clocks in at 7:57, the idea of rounding is that you can round that person's time clock or time punch up to 8 o'clock. So I often talk to employers who have one or two portals or computers for employees to clock in on, and they, you know, when it hits 8 o'clock, they have a line of 30 people that are going to try and clock in. So employers like to have a practice where there's a window of employees can clock in, and from before their scheduled start time and even after the scheduled start time, and then the employer would just round that time clock to the nearest 5 minutes or nearest quarter hour. But the problem is that this practice is allowed by federal law, but it's not allowed by California law. So initially, the court said in a See's Candy case that you could do rounding as long as it's neutral in its application, meaning the amount of time that people lose is on average equal to the amount of time that they gain by clocking in late and having their time rounded down. A problem with that is, again, there's really no California authority for it. There's no California statute or regulation that says you can round. And that practice essentially requires an averaging of wages, which California law expressly doesn't allow. So there's been more and more cases attacking rounding practices. After See's, we had this Woodworth case. I won't go into the details, but the case that's going around right now, that's being appealed right now, is the Camp versus Home Depot on rounding. At the appellate level, Home Depot lost, saying that you shouldn't round anymore. Home Depot has appealed. It's currently before the California Supreme Court. And even though the labor groups, the employment groups, the employment-friendly law firms have been pushing have been submitting amicus briefs and are pushing the Supreme Court to overturn and allow rounding, it's probably not going to happen, in my opinion.
We definitely recommend getting against it, Kurtis, but also just wanted to remind everybody, because of the meal period penalties in California, if employees are clocking in early, let's say your shift starts at 8 and they're clocking in at 7:55, that 5 hours for lunch is not before 1 o'clock. It's now before 12:55. So you want to make sure you're paying attention to that, because on the surface, you just go, oh, they're working 8 to 5, everybody takes a lunch. You know, they have to go before 1. They have to go before the end of their 5th hour. So you're going to have to mark it from the time they actually clock in.
Yeah, that's exactly correct. The next case we want to talk about is the Naranjo case. This case I was not a fan of. So basically the court held that meal penalties, rest break penalties, and other penalties that are established by the wage orders and the labor code really aren't penalties, meaning a penalty is designed to encourage the employer to comply with the law. The penalties are not designed to compensate employees for time worked, which is what wages are. But the court is now saying that penalties are basically wages, and that if a penalty is not paid upon separation, then the employee is entitled to waiting time penalties, because I know this is sounding redundant, but meal and rest break periods and other similar periods, if not paid before termination, are wages, must be reported on the wage statement, must be paid out at the regular rate of pay, and will create a lot of business for employee plaintiff attorneys. The Naranjo case is partially being appealed. We'll get to that in another slide, but the part about penalties being considered wages, that's probably going to stick. That's probably not going to change. And one more point to make about penalties being wages is that penalties can no longer be settled. So before we could compromise and settle penalties, if an employee racked up $1,000 worth of penalties, we could settle it for $500 because penalties weren't wages. But now, since penalties are wages, apologies for saying that 1,000 times. Now that penalties are wages, they cannot be settled. They must be paid as wages if incurred. Linda, are you familiar with STIRCYCLE, the National Labor Relations Board case?
No.
Yeah, so I don't like this case either. This is a National Labor Relations Board case that's interpreting federal law. It's a stupid decision that is probably not constitutional, but it's what we have to stick with right now. Another problem is we don't really know, as when I say we, I mean employment lawyers, we don't really know what we're doing with the STIRCYCLE decision right now. So STIRCYCLE basically says that an employer cannot adopt a workplace policy if that policy has any tendency to restrict or chill an employee's right to engage in a protected activity, such as discussing wages and working conditions, discussing hours, discussing health and safety concerns. So I'll give an example. So an employer can have a policy that says you cannot have your cell phone on your person while you're working. And before we could say that policy is enforceable because it's distracting, people don't do work, it could cause safety issues. But now the thing is, if an employee is not allowed to have their cell phone on their person while they're working, they arguably are not allowed to, they arguably would not be able to take pictures of unsafe working conditions or record conversations with their fellow employees about their working conditions or their pay or working hours. So under this new STIRCYCLE decision, a policy that says no cell phone on your person while you're working is going to be unenforceable. It's going to be illegal and will violate federal law. There is still an exception under the STIRCYCLE decision that says that a policy that has a tendency to chill speech or chill an employee's ability to engage in a protected activity can still be enforceable if the policy is narrowly tailored to the objective that the employer is trying to accomplish, and that there are no other restrictive ways, no other less restrictive policies that would still accomplish the employer's objective. So in other words, it's saying that if you're going to have a policy that says no cell phones on your person, it needs to be limited to a situation where there's a compelling employer interest, such as safety. So I could see a policy where an employee is prohibited from having their cell phone on their person while they're operating an excavator or a forklift, because that's a safety sensitive position. It's narrowly tailored to that position, and there's no other less restrictive means of guaranteeing safety for that position. The problem with this new decision is there's a lot of policies that employers adopt, and we really haven't had the time to go through all the different types of policies that employers can adopt and see and determine and analyze what the effect of this decision is. So we'll see what happens with STIRCYCLE. It might get appealed because this was just a case before the National Labor Relations Board, and appeals are permitted to happen to the local circuit court of appeals. So we'll see what happens. And then as we go through and we work through different policies, we're going to analyze and see what we have to do to change workplace policies to make them narrowly tailored. I don't have a lot of information I can provide on STIRCYCLE right now, just to say that we're working on it, and we're slowly advising and coming up with ways to maintain employer interests and protect employee rights. Okay, the next case we want to talk about is Groff versus DeJoy. This is a United States Supreme Court case on religious accommodations in the workplace. This basically says that an employer must provide a religious accommodation in the workplace unless the religious accommodation would create a substantial financial obligation to the employer. This is a little different standard than what we had before. The standard for allowing, or the standard for prohibiting a religious accommodation request was lower. This is just raising that standard a little bit. So in this case, this was a United States Post Office worker who joined the post office because he didn't have to work on Sundays, and his religion prohibits him from working on Sundays. But then the post office entered into an agreement with Amazon to start doing deliveries on Sundays. And this guy was like, no, I'm still not going to work on Sundays because it's against my religion. And under the old test, the US Post Office would have won and could have forced this guy to work on Sunday, the day that he's not allowed to work according to his religion. But the Supreme Court said because there's no financial loss to the US Post Office by allowing this guy to take Sundays off, then the post office has to allow this guy to take Sundays off. So we're still observing and seeing what the ramifications of this case are. But just know that if an employee requests a religious accommodation in the workplace, it's probably a good idea to contact your legal counsel and have that discussion about whether the accommodation can be requested or whether the accommodation can be denied. And the last case we wanted to bring up, this is Rains versus HealthWorks Medical Group. Linda, are you familiar with this case?
I don't believe so.
Okay, so this is actually, I think this one just came out actually. This really isn't a new law, but it's a case I wanted to include because oftentimes when I'm revising or drafting an employee handbook, I make sure that the policies in the handbook on harassment, retaliation, and discrimination apply to third parties, to vendors, suppliers, contractors, meaning that if you're an employer and you have a vendor that comes onto your premises, you are also obligated to make sure that that vendor doesn't harass your employees, doesn't discriminate against your employees, or doesn't retaliate against your employees. That's basically what happened in this case. This was a third party that engaged in FEHA violations, and the employer said, no, that wasn't us. That was the third party. You need to sue the third party. But the court said, no, FEHA applies to third party violators as well. So absolutely make sure that in your handbooks and your practices that you are protecting your employees from potential third party FEHA violators.
That doesn't sound like much of a change to me, Kurtis. It seems like that has been the
it's
law.
not, but it's the first time that I've ever seen a case on it.
Yeah, I mean, we've included that in our training for years, like when we do the manager harassment prevention training, is reminding them that they have an obligation to prevent both ways, right? Prevent their third parties from harassing their employees, but also prevent their employees from harassing third parties. So it cuts both ways on that. This one, we just wanted to remind everybody that there is going to be a new requirement. It's already been signed into law, but now there's nothing for you to do right now other than prepare for July 1st when this requirement goes into effect. This requirement will apply to most employers. There are some exceptions, but you're going to have a written workplace violence prevention plan. Think of it very similar to the COVID prevention plan, because when you look at the list of requirements, there's like 13 different things you have to do. Very similar in nature, just in terms of the structure of what you have to do for the plan. You also have some additional record keeping and training requirements. So that's coming July 1st. Just be aware of that, and you can start working on putting that plan in place anytime. And then, of course, Kurtis, there's always more to come later in the year, so we never know what surprises are in store for us. But what about these pending cases? And then right after this, again, just to remind everybody, if you have a question, go ahead and drop it into the Q&A. And Denise has been monitoring those, and we'll take questions right after Kurtis updates us on all of these different pending cases.
We're sticking to our schedule. We're sticking to our agenda pretty good here. So we should have plenty of time to answer questions, and we're happy to answer any questions that we can without providing any specific or direct advice. So I mentioned before some of these cases, and I mentioned that arbitration gets litigated all the time. There are currently 5 cases before the before the California Supreme Court on arbitration. There's one case I mentioned before, or was in the slide, I didn't talk about it, on separating out PAGA claims from arbitrable claims. Pretty sure that one's going to lose, or at least from the employer perspective, that's going to be a loser. Or mentioned the unconscionable case. I don't know what's going to happen there. And then there's 3 other cases that are just on like procedural stuff that nobody here would really care about. I barely care about it. But the emphasis is arbitration is such a hot topic. It changes daily. You got to stay on top of your arbitration agreements. I stay on top of it so I can advise and I can have compliant arbitration agreements, at least that are compliant as of the day I write them. So please stay on top of that. Camp versus Home Depot and rounding we mentioned. Castellanos versus State of California. This is app-based driving. We think this is going to be a win. After Prop 22 on app-based driving, there's some people try to challenge the proposition. They've lost, and they're probably going to lose before before the California Supreme Court again. There's some questions on PAGA. It's questions on whether PAGA cases can be dismissed because they're not manageable. We'll see what happens there. There's some questions on this Huerta case about time spent waiting to get into an employer's premises and going through security and getting bags checked. There was an Apple case that the California Supreme Court ruled on that was bad for employers, and Huerta kind of follows the same reasoning. So we're expecting this one to be bad. We're expecting to lose. And I mentioned Naranjo is, again, partially appealed to the California Supreme Court. They're just trying to interpret the definition of willful, intentional, and knowing. The issue is that the current case law says that willful, intentional, knowing basically means if it happened, if a violation happened with your wage statements or other wage reporting practices, the violation happened, it was willful, which sounds more like strict liability, even though the statute is trying to impose some kind of mental element, some kind of intent. So we'll see where that one goes. I don't have much faith in the California Supreme Court. They'll probably lose, but it's a good argument. It's a good argument that should be brought and should be argued. So we'll see where that one goes.
Thank you so much,
Those are our pending
Kurtis.
cases.
Thank you so much. Denise, looks like we have a ton of questions regarding sick pay.
Yeah, so I was going to say, let's go back to that one because that seems to have a lot. So does the PSL increase apply to pre-2016 grandfathered policies?
Yeah, so if you're relying on a policy that was grandfathered in that existed prior to actually it should be July 1st, 2015, that policy would still need to comply with these increases. So if your policy from July 1, 2015 doesn't allow for 5 days per year, then you'll need to scrap that policy and adopt a new policy that complies with the current law.
Okay, paid sick time is for all employees regardless of on the amount of employees that you have?
Yeah, that is correct. There's no employee
Yeah.
limit. There are limits for new employees. It doesn't apply to employees unless they've worked for 30 days for the employer, and employees are not able to start using their paid sick leave until after 90 days of employment, but it is all employers.
Okay. Someone just asked me about getting your information. So in a minute, we'll put after the Q&As, we'll put up Linda's and Kurtis's contact information so you could reach out to them with specific questions. If your employees work 5 9-hour days, will 5 of those sick hours need to be overtime if they make that last hour each day as OT normally?
So I would say first, you know that there's an alternative work week possibility in California. So if you do have a schedule where you're working 5 9-hour days, you might want to talk to one of us about helping you put an alternative work week in place. But if I understood the question correctly, you're saying, hey, right now my employees are working 9-hour days and we're paying 1 hour of overtime each day. The hours for sick time have to be paid at the employee's regular rate of pay, which is not their usual rate of pay. So regular rate of pay is a different calculation. So Kurtis, maybe jump in here and make sure I'm answering them correctly, because the question to me is a little confusing.
Yeah, I think the question is when somebody uses a paid sick leave day, how much are we supposed to pay them? So if somebody normally works 45 hours a week, then they should get that greater of 5 days, which would be 45 hours of paid sick leave time. So that would be an example when it's not really 40 hours a week, it's the greater of 5 days, which in that person's situation would be 45 hours. Paid sick leave is not supposed to be paid at overtime premiums, because overtime premium is extra money for staying longer at your work than the law wants you to stay. If you take a paid sick leave day, you're not going to work, so you're not entitled to any kind of overtime. You should still get paid 9 hours for that day, but it's 9 hours, like Linda said, at the regular rate of pay.
Right. So because there's not hours worked, so you're not paying overtime because no work was performed, if that makes sense.
Exactly. Good way to put it.
Okay, another question. We are on the accrual method and already have a cap set at 80 hours and have been doing that for all of 2023. What else do we need to do to be in compliance with the new law?
A few things. One, you need to update your written policy, assuming that the policy reflects what you've been doing. Hopefully that does, then you should be good there. You have to allow the usage up to 5 days or 40 hours, whichever is greater. So again, if you're working 9 or 10-hour days or something like that, it might be higher than 40 hours, but you would have to allow the usage. So it sounds like your accrual cap is compliant. Just make sure the usage portion is compliant as well. Anything else, Kurtis, you can think of? Broke up a little bit there, but go. I think he said
that's my exact comment. Sorry.
Okay.
You talked a lot about front loading and your recommendation to front load the hours. Confirming that if you front load, the law still is that you don't have to roll it over. So if you front load the hours, do I need to roll it over?
You do not need to roll it over. And that's one of the reasons that we recommend just front loading. The only time that I ever advise clients to do the accruals, if they've got a lot of very part-time employees, right? So they've got somebody that works just, as needed, a few hours here, a few hours there, then it might make sense to accrue. But honestly, it's so much easier just to front load it and then go from there.
Okay. If you have PTO policy, does it need to be paid at a regular rate of pay?
Yes, Kurtis, you stopped.
I actually don't think I've ever been asked that question. So now that I think about it.
Yeah, I mean,
But
I say yes.
It would need to be, yeah.
It would need to be.
Mhm.
because you have to comply with the higher standards. So
Right.
for a long time, we said, hey, just put everything together and make it a PTO policy and just have vacation and sick rolled into one. Now I tell people exactly the opposite for a few reasons. One is that requirement, right? Because it has, so sick pay has to be paid at the regular rate of pay, which means it has to fold in bonuses and incentives and commissions and all of that. That's one reason, because you don't have to do that with vacation. You also do not have to pay sick pay out upon separation, where you do vacation. Once they're combined, you have to pay out PTO. So for me, I don't know why anybody would want to put it all together. I don't think it's that big of a difference. And I don't think it's worth it to employers, but that's just my 2 cents on that.
Yeah.
Agree.
Okay, and just as a reminder, if people have to jump off, we are recording this and we will have this posted to the Ethos, and also I believe you posted to the
Right.
to
Yeah,
your
we
channel.
posted to our YouTube page.
Yep.
Perfect. Okay, I'm going to change the questions up a little bit so we make sure we
Denise,
get a couple different topics.
before you do that, I think I saw one other question I just wanted to address on the sick pay. Sometimes people call me and they say, well, I've got somebody that's part-time, so can I prorate the amount of sick pay? And the answer is no. So you have to maintain that minimum. I don't know why the legislature didn't allow for that. To me, that was a big mistake. But if you have somebody that says just working 20 hours, you can't say, well, I'm just going to 20 hours a week, I'm just going to give them, you know, half the benefit. You cannot do that. They would still be entitled to the full 40 hours.
Interesting. Certainly different than when I started working.
Yes.
Okay. Is there a cap on reproductive loss leave? You guys talked about the requirements for leave. Can it be used more than once a year?
It can. It's per event. It's not limited to per year. So if there's a miscarriage in January and then there's a stillbirth in December, and I'm just coming up with making stuff up, the employee would be able to use the leave, protected leave twice that year.
And just to clarify, there's nothing you can do to request the paperwork, or what is it that you're required as an employer?
Nope.
First,
Can't do
just
it.
check the employee's work for it. Yeah.
Yeah. That's the
Because so
part
much of it is private, you know, and protected health information. So
that's the only part of this that I object to, right? I just think, you know, more and more, but sort of, we went through this in part with COVID, right? An employee says they have COVID, you pay them to stay home. And I'm like, really? You can't require a test, like anything like that. And it's sort of like that here. And I get that it's personal health information, but we require employees to provide us with a lot of stuff. They wouldn't
you
have to
still
say
take-
why, but I would think that they would need to do something to, you know, justify the leave.
note that says employee had a loss or employee had an event and needs their 5 days off.
Right, something, but
You don't need to be specifics, but there should at
Yeah.
least still be like a doctor's note.
something. Yeah. I don't know how you would do that with a failed adoption, you know, but anyway, that's my only part about that one, but I agree with Kurtis. It's good. I've had friends and family go through it, so.
One other question, and then I'm going to change topic again. So, does reproductive loss also include abortions? Do we know?
Not that I know of.
I don't remember seeing that. That potentially could be covered, you know, under a regular, you know, leave, a California Family Rights Act or something like that, or pregnancy disability leave or something, potentially, right? But I'd have to look specifically, but I don't believe it's covered.
Mhm. Plus, it's personal, so I don't know how you could ask that question.
Right.
Right.
Okay, so we had a question about cannabis. So, they're a construction company, and it's their understanding that they can still test prior to hiring and require a clean drug test. Is there a different rule for office workers versus workers on the construction site?
So Kurtis, let me take the second part and you take the first part, okay? So
I'd almost rather have this conversation off, like, because there's a lot that goes into it, but yeah, I'll try to take the first part. So you can test prior to hiring, but you can't test for past or off the job usage. So you can only test to see if that person that day when they go into the clinic is subject to psychoactive compounds. And there's a good chance that's not going to happen. There's a good chance somebody's, I mean, it's not going to happen where somebody consumes and then goes and takes their test, right? So you can still test, but I don't know why you would.
So, yeah, I mean, I think that because this particular client may have some government contracts, right, that require it, there's things
Sure.
like that that would cause them to want to continue to do it. You could also send people to a clinic to have a pre-placement physical to make sure that they don't have, you know, that they can do the essential job functions. They don't have any pre-existing conditions that would prevent them performing the essential functions. So there's other things like that. But what Kurtis is trying to differentiate is, you know, right now, if you went and you took a drug test and it tested positive for pot, you could have smoked pot, you know, 2 months ago someplace, and it may still show positive in your system, but you're not currently high. You're not going to be, you know, drilling something, you know, under the influence. So now the government's trying to say, okay, clinics, you need to be able to differentiate between like current usage versus something that's just still in your system from when you did it, you know, 2 Saturdays ago or something like that. So that's why you need to talk with your clinic about it. The second part of the question was, can you have different policies? And the answer is absolutely, right? So, you know, so for example, you wouldn't have office workers fitted with respirators because the guys out in the shop or the people out in the shop do, right? So you can have different policies, just make sure it's on a non-discriminatory basis. So, you know, you don't say like all of the women get treated this way and all the men don't, or all the Hispanics and all the blacks and all the whites and all the, you know, none of that stuff, right? But you could do it based on job class because there's different essential job functions. Some are more physical than others.
Okay, great. For the rebuttable presumption of retaliation, if the employee exhausted their FMLA and CFRA leave, do we still need to keep their position open for them?
This is my big pet peeve.
I know, right? So the
Kurtis
answer
and
isn't
I've
even
had this
related.
conversation many times.
The answer isn't even related to the question. That's what's the confusing part.
Go ahead.
So just because somebody exhausts their CFRA or FMLA doesn't mean that they're unprotected. So when somebody exhausts their CFRA or FMLA leave and they're still disabled or have a medical condition, you still have to treat that person like you would any other similarly situated employee under the ADA or under FEHA. So it depends, but probably yes.
Yeah, this is a big issue. We have one client that an employee has been out since last year sometime, right? And it's just sort of ridiculous to me that, you know, I'm continuing to tell them you can't fill the position, you know, so there's other things you can do. I mean, there's what we call a rating letter that can be sent to the employee's doctor through the employee asking what's the likelihood that this employee is going to return. We have a situation, I have a call later on today with a client who has an employee out on a leave of absence, but she's not providing the doctor certification. That's a different issue. So there's other things that you potentially could release that employee for. But to Kurtis's point, it's like that's the issue right now with this new law, is that we already assumed, hey, we're ripe for some action if we fire somebody on a leave of absence, right? But now it's like sort of in the law, like, oh yeah, if you do this in 90 days, we're going to assume that you retaliated, and then you're going to be forced to defend yourself. So the question is that what you want to do?
Yeah, that's a tough situation.
It is.
Let's talk about the cell phones. You guys talked about cell phone usage. Somebody wants to know, can we restrict cell phones to lockers unless they are on a meal or break period?
To the question, I need to know more about the employer, what the circumstances are, what the employer's objective is for restricting cell phones to the lockers. I just need to have more information. It's a conversation that really should be had outside of the webinar.
Mm-hmm.
It's not an easy black or white yes or no question anymore.
Yeah. I mean, there was a new law last year that also had to do with, you can't, you know, employees have to have access to their phones in the case of an emergency and all sorts of other things. So I would say more likely yes than no, but you'd have to go through that analysis.
So contact Kurtis or Linda with your questions directly. I think that's really so that they could walk you through the situation for your business. Should we pay expenses to all remote employees regardless of where they're located, if out of state?
I would say, so I'm not going to give a yes or no answer. My answer is going to be what the case that we discussed is only California law. So when you have employees that are working in other states, say Arizona or Nevada, you're going to want to analyze the law of those states that the employees live and work in and see what the reimbursement requirements are for those states. Because California is easily the most restrictive, requiring the most payment.
Yep.
And not all states have the same rules.
Yeah, in fact, it's sort of funny to me, like when you look at most states, federal law doesn't require meals and breaks. They don't require expense reimbursement. They don't require a lot of things. We're so used to it, we assume that all other states do it, but that's not the case. So there's only a handful of other states that I'm aware of, like Massachusetts has a mileage policy. I think somebody else has one. That's about it. There really isn't a lot of requirements. However, having said that, I will give you a non-legal answer to this, which is to say you do need to think about impact on your culture and on your morale and on other things, right? So if an employee is living in Nevada, let's say, right, and all of their coworkers are in California and the coworkers are getting that extra money each month because they're working remotely, but your Nevada employee isn't, right? That conversation is going to take place and there's going to be questions for you. So, you know, I don't know that you want to respond with, well, Nevada doesn't require us to do so. You can perhaps, but you have to think about, is it easier just to pay everybody the same amount since they're all working remotely and using their same, you know, electricity and internet and all of that. That's my 2 cents. I'm not saying you have to, just think about that.
Curtis, you have anything to add on that?
No, that's great.
Okay. Oh, he agrees with you. So there's 2 other questions in different categories. So let's talk about that. Can you have expectation or rules that a current employee can compete with the current business? So talking about the non-compete earlier, meaning that they couldn't freelance or work for a competitor while they are employed with your business.
Yeah, so you can still, all current employees have a duty of loyalty to their current employer. You can still prohibit current employees from currently competing. So if I'm working for Merhab Robinson Clarkson doing corporate real estate and employment, I can't go work for Rattan and Tucker doing corporate real estate and employment because that's competing with my current firm. But if I want to go work at McDonald's at night, there's nothing that my current firm can do to restrict or prohibit me from doing that.
Interesting.
Kurtis, is it sufficient just to have that policy in the handbook, or do you feel like employees need to sign something separate?
I usually just include it in the handbook. If an employer wants to have a separate policy, I'm okay with it. I don't object.
But it doesn't need to be signed like an arbitration agreement or something like that. Yeah, we just have it in the handbook too.
Right.
Okay. Is there a company-wide, if there is a company-wide start time posted daily and an employee arrives at the job location 15 minutes early and clocks in, can that be rounded to the posted start time?
Don't do it. Go ahead, Kurtis.
I wouldn't. I would pay the employee from when they clocked in and then discipline the employee for clocking in early.
And then to Linda's
give them
point,
a written warning to not do it again.
Yeah, and to Linda's point, then it messes up your lunch hour, right?
Right.
5 hours. Okay.
Yeah, it can be an issue, right? And this wasn't something that I was always, I guess, really attuned to. And then a handful of years ago, somebody said that and I was like, oh yeah, I hadn't even thought about that. And then since then, you know, we've seen that with employers. It is a problem when you have people clocking in, you know, and you only have a couple of clock-in spaces, you know, places they can go do that. And there's a line of people at the door. How does everybody clock in exactly at 8 o'clock or exactly at 5 o'clock in the morning or whatever? You can't do it, right? So you have to give some thought to that. If you start requiring them to have their phones and use that, then you've got the issue of, do I have to pay them, you know, for using their phones to clock in and out? So there's a lot of different things to think through on that policy.
Okay. The rest of the questions honestly are all about accruing hours and how to do it and things that we've covered. So I think they need to reach out directly because they have specific situations in their companies to reach out either to you, Linda, or to Kurtis to discuss their particular situations and how they need to handle it with their employees and with their policy.
Yeah, there is one more comment I want to share on paid sick leave, maybe two. You'll notice in the slides that I didn't talk about the 120-day requirement or the 200-day requirement or these confusing numbers that the legislature wrote and that you're seeing in e-blasts and articles. The comment is that the accrue 24 hours by the 120th day and accrue 40 hours by the 200th day, that's really only applies to the alternative accrual method, meaning you're granting employees 6 hours of paid sick leave per month. The idea is that you could do an alternative method so long as you meet these milestones. And if you grant 6 hours per month, you're going to hit those milestones. The 120 and the 200 do not apply to the front load. They do not apply to the standard accrual method. So there's some questions here about we do the standard accrual method. Do we have to hit the 120 and the 200-day milestones? No, you don't. You just accrue 1 hour per for every 30 hours worked. The standard statutory accrual method comes out to like 5.77 hours a month if someone works a normal 40-hour work week full time, but that's just not the standard that's required for the standard accrual method. So the reason why I didn't include that information in the slide is because it's just simply confusing, and I just wanted to simplify it, give just the main information that an employer needs to know to comply with the law.
Yeah. And as we've said a million times, just front load and be done with it.
Yeah.
Don't worry about all of this accrual stuff because you do have to comply. Same way if you have a PTO policy, you do have to comply with the accrual methods and the usage numbers under, the law. And so you can't just go out, and I've had people try all sorts of interesting things, like, well, what if I do it at the end of the year? What if I, do it for 4 months and then stop? What if I, there's all sorts of ways that they want to try to comply with this. And the easiest way is just to front load it. If you're going to accrue, I personally would use the just standard accrual, the one for every 30 hours worked. There's other ways to do it though. So think about your policies, think about whether you want sick and vacation combined, because I would also recommend separating those out, and then put everything in writing. And the other thing I'll say is make sure that your payroll company is updating everything. Don't assume because, oh, they have plenty of clients in California, they'll automatically update my accruals, because they won't do it. And you're still on the hook if your payroll company is not doing the accruals correctly. Back to you, Denise.
Okay, I was
That's
gonna
it for
say,
me.
I think that has answered most of our questions. Like I said, if anybody has, trying to get back to them and say to reach out specifically to you guys with the questions. Just a
Awesome.
reminder that the webinars will be posted on both. I just got that question again. Will be posted on both the Ethos HCS YouTube channel and the Merhab Robinson Clarkson Law Corp YouTube channel. Probably later on today or tomorrow for sure, depending on when we get them. And that's all I have today. Thank you both for being here and giving us knowledge again for all the new things we have to think about as employers for next year.
Thank you, Denise. Thanks, Kurtis. And thanks to everybody for joining us. Happy holidays to everybody.
Mm-hmm.
Great,
Have a
thank
good
you.
day.